Hi everyone, today we will talk about a very important question. Can a grandson claim rights in his grandfather's property? We will explain this in simple words, no complex law talk. People often think that a grandson automatically gets part of his grandfather's property. But the law in India does not always say this. The actual answer depends on several things. Let's break it down. First, we must understand the type of property. There are two main kinds. Self-acquired property, that is property the grandfather bought or earned himself. Ancestral property, that is property that came from earlier generations and has been passed down in the family. If the grandfather earned the property himself or he bought it, this is called self-acquired property. In this type of property, the grandson does not have a direct legal right just by being born. This means the grandson cannot simply walk in and say, I want a part of this property. Instead, the law first looks at the grandfather's own closest heirs. If the grandfather left a will, a legal document saying who gets what, then the property goes to who the grandfather chose. That could be a son, daughter, wife, or even a grandson. But only if the grandfather wrote it in the will. If there is no will, then the law decides who gets the property. When a person dies without a will, this is called dying intestate. Then, the law decides who inherits. In India, for Hindus, this law is the Hindu Succession Act. Under this law, important people get the property first. The property goes to the grandfather's class 1 legal heirs. These normally are the wife, the children, sons and daughters, and sometimes the mother of the deceased. A grandson is not included in class 1 heirs in this situation if his parents, the father or mother, are alive. Here's an important point. If the grandfather's son, the father of the grandson, died before the grandfather, then the grandson can step into the father's place. This means the grandson can inherit what the father would have gotten. Imagine grandfather has one son. That son dies before the grandfather. Now the son's place may be taken by his child, the grandson. So in that situation, the grandson can inherit the grandfather's property share that belonged to his father. Now let's talk about ancestral property. Property that has been passed through generations. This is different. In ancestral property, a grandson may have birthright to a share from the moment he is born. But here's the twist. Recent court decisions have said that even for ancestral property, a grandson cannot directly claim a share while his parents are alive. This is because the law still follows the list of heirs and the parents are ahead in that list. In 2025, the Delhi High Court made an important decision. It said that grandchildren cannot claim rights in their grandfather's property while their parents are alive. This applies under the Hindu Succession Act. If the property passes intestate, no will, the property goes first to the parents. If someone thinks they should get a share, the best step is to talk to a lawyer. Only a lawyer can explain your specific case. Laws may vary based on the religion or situation. This video explains general principles. Thanks for watching. We hope this helped you understand the basic rules about a grandson's rights in a grandfather's property in India.